I'm trying to figure out how covering up something that wasn't illegal makes it illegal.
I don't think that Trump's lawyers ever quite said it that clearly.
All right. Thank you for checking out Fill in the Blanks again. I appreciate you sharing the episodes and for your feedback. And yes, I do read your comments, so keep them coming. Today's something really different. We are obviously digging deep into the aspects of Donald Trump's trial, and I have someone here that I have respected for a long, long time. I consider him a really good friend. He has left an indelible mark on litigation in the United States. I'm talking about Rod Phelan. He's a former litigator from Baker Botts, a really renowned law firm. He graduated cum laude from Duke University School of Law. He's been recognized as one of the best lawyers in Dallas 11 times from 2011 to 2021 and was named to D Magazine's Best Lawyers Hall of Fame in 2022. Rod has a brilliant legal mind and an unwavering commitment to justice. When I say this is something really different, Rod is going to be an expert on Dr. Phil Primetime, taking a hard look at what's happened in this Trump trial, as I'm referring to it. And when I prepare for these and have top-level experts, I like to sit down with them ahead of time and let them educate me about what they know and at least prepare me enough to be able to ask intelligent questions. Because this is so complex and there's so much going on, I decided to just record this working session. So I'm pulling back the curtain and letting you guys listen in, look in, and see what's going on in this preparatory session for a really important episode of Dr. Phil Primetime, where I'm sitting down and talking to Rod Phelan and getting educated about what he thinks about what happened in this trial. He's a lawyer. I'm not. My expertise is in the jury part of this. So he's going to learn me up about what's going on. Right, Rod?
That's a big job. I'll give it my best.
Yeah, I'm sure you will. So you've been following this trial pretty close along the way. Obviously, you haven't been in the courtroom. We didn't have cameras in the courtroom. First, give me your 10,000-foot view of this thing. What's your feeling of it? Should this have happened at all? Was this a legitimate trial? Was it a travesty, as I've referred to it? What's your gut level take on this?
The case should not have been filed. It was filed, as I think everybody knows by now, by a district attorney who ran for office and won, promising, among other things, to get Trump. He then passed on this very case, took a lot of heat for doing so, and when Letitia James began to get all the publicity she got for going after Trump, he did a 180 and decided to file this case. The gist of the case is that Trump paid hush money, and that was a crime, and then he tried to cover it up. That's the heart of the case, and as a matter of law, it's wrong. Hush money never is a crime and wasn't this time for really compelling reasons, and those are that this woman paid to keep her secret, had no duty to tell it. She had every right to sell it. She had every right to tell it or sell it. She chose to sell it. Paying her to keep it quiet was not a crime. And if the judge had recognized this, he would have dismissed the case right out of the box.
All right, but let's look at this from somebody that doesn't know anything about the law, somebody that's just looking at this purely from a lay perspective. When you say hush money, that sounds serious, right? I mean, that sounds, I don't know, smarmy, shady. It sounds illegal.
And that's a big part of the problem that Trump had once he was faced with this case. There was an allegation that he had sex with a porn star. He denied it. There was an allegation that he paid her not to tell about sex with him. he denied paying her. He said somebody else was responsible for paying her, and he didn't even know it had happened. So when you're in a case and you have drawn those lines in the sand as he did, I didn't do it, and I didn't pay her, and I didn't know she got paid, the jury, when it hears that story, is going to raise its eyebrows. So he made a high hill for himself to climb by beginning this case denying something that most people would think, I don't know about that.
Yeah, this is kind of like the dog bite analogy, right?
Not my dog.
Yeah.
Yeah.
You didn't get bit, and if you got bit, it wasn't my dog. He's saying, I didn't have sex with this woman, and I didn't pay her to not say I had sex with somebody did, which is fortunate, but it wasn't me.
And by the way, I then did pay him back 2 or 3 times what he paid her.
Yeah, for whatever reason. So it doesn't pass the smell test, but whether he did or didn't have sex with her is of no legal import whatsoever, is the point. Whether you like that fact or whether you don't, paying hush money to somebody to not say something that would reflect poorly on you is not illegal.
Correct. It is not, and it is not illegal when it is done by a political candidate either. And that was where they tried to catch him and call him, say that he was committing election fraud because he was running for office trying to silence someone who had something bad to say about him. But everyone who has ever run for office has gotten together with his supporters and said, look, there's some good news, let's play that up, and there's some bad news. Let's try to keep the spotlight off that. Let's deflect it. Let's hope it doesn't come out. There's nothing wrong with that. Every candidate does it.
Okay, so let me break that down. And I know I'm drilling down on this because I'm looking at this from a jury standpoint. What is the jury entitled to hear? What they do hear needs to be appropriate to the case, not prejudicial. It needs to be something they're entitled to hear. They need to hear everything they're entitled to hear and nothing they're not entitled to hear. And it needs to be in the right context because the jury, if we believe that the jury system works, then they're not supposed to listen to the radio, watch television, read the newspaper. They're supposed to only judge this based on what's presented in the courtroom. So nothing should be presented that is outside the definitions of the law and what is admissible and what's not admissible. So you're telling us that from a legal standpoint, a candidate has no duty to disclose something that's negative about themselves under election law, common law, any other. They have no duty to be forthcoming about something that's negative about them to the public.
Correct. Nor did she have a duty to tell that tale.
She didn't have a duty and he didn't have a duty. Okay, they didn't violate a duty by withholding this information from the public. So she has a right. She didn't have a duty to tell it, but she has a right to tell it if she wants to. He has a right, or somebody on his team or a friend has a right to go to her and say, we'd rather you not talk about this, and we're willing to compensate you if you won't.
In this case, that's true. And in this case, she had hired a lawyer to try to negotiate a deal with Trump. She believed he was vulnerable running for office. She had a story to tell, and she was the one who initiated the discussion about whether she should be paid or should go public. And Trump responded, as I think many candidates would, and as was entirely legal, by saying, I don't want you telling that tale. And she didn't. So I misstated something there. She didn't talk to Trump. Her lawyer talked to Trump's lawyer. Trump was never in that loop, but that was the essence of it. Her lawyer said to Trump's lawyer, hey, I got a story. Will you pay me not to tell it? And that lawyer said yes.
Okay. And there's nothing wrong with that.
It's not a crime. Here's something that's hard to sell, but it's got to be said. voters don't have a right to know what your skeletons are. And if you can keep your skeletons hidden as a candidate, you're not committing a crime. You can criticize someone's morality for having had these skeletons in his closet, having done whatever it was that put those skeletons in his closet. But Trump has been convicted for having those skeletons and paying to keep them quiet.
Okay, here's the thing. And we're talking about morality and legality. And those aren't always the same thing. Sometimes they are, sometimes they're not. And here I'm asking about the legality of it. It's not illegal for him to not tell. It's not illegal for her to accept money to not tell. It's not illegal for someone in his camp to pay her to not tell. That's not illegal.
And it's not only not illegal, it is not election fraud, which is the case that the prosecutors told to the jury, described to the jury. This was election fraud, they said.
Okay, and how is it election fraud? What's their theory?
The prosecution's argument was that the hush money itself was a crime. They just flat said that it was, and that when Trump, in effect, paid blackmail to keep it a secret, he violated New York's election law, which makes it a crime to use an unlawful act to promote somebody's election. So they had to start by saying, okay, that was an unlawful act, paying her. And New York election law made that act a crime because you did it to promote Trump's election. Then they tied it all together by saying, and then you covered it up with business records that misdescribed it, and that business records was used to conceal the fact that you had committed this election fraud crime.
Was it election fraud?
It was not election fraud because the act that they had to have to make it illegal was paying hush money, which is legal.
How did they make the jump from doing a legal act becoming an election fraud?
Mainly by pointing to the evidence of the lengths to which Cohen himself and Trump's organization went to try to hide what had happened in the payment of Stormy. There were a lot of documents that Cohen generated that were unnecessary unless he was trying to hide it. Trump's own people booked the payment as a legal expense, and people have argued that, no, it wasn't that. It was hush money.
Okay, so if they had these entries covering up a legal act, what's the problem?
I don't think that Trump's lawyers ever quite said it that clearly. If the act is legal, covering it up can't be illegal. It's that simple. It might have been foolish to cover it up, just as it might have been foolish to do whatever it was that led to the story. But as you said, this was a criminal case, and it somehow went off on the morality of what was going on. And I can see how a jury would be confused by that.
Okay, so if I go in a store and buy something, whatever it is, a pair of socks, pay the money, I got the receipt, I own the socks, and then I go through a lot of machinations to cover up having bought those socks, does buying those socks become illegal?
Well, on the prosecutor's theory, yes, but I think we could come up with a better analogy to make the point.
Well, I'm trying to keep this G-rated here, but the act was not illegal. I'm trying to figure out how covering up something that wasn't illegal makes it illegal.
You're absolutely right. It doesn't. But what the state argued was that Trump created business records that misdescribed what had happened. Trump or his people created those records. And there's a statute in New York that the only one that he was charged with violating, which makes it a crime to falsify business records for the purpose of concealing or committing another crime. So they said that when Trump or his people misdescribed the payment for silence, they were violating this business records statute. That was the argument, and that argument prevailed.
So they said that what he did was he violated a business records statute.
With the documentation of his payment that was reimbursing the payment to Stormy.
Okay, which was legal.
Which was legal. Paying Stormy was legal, but when his lawyer Cohen did that, reimbursing Cohen for paying Stormy was legal.
Okay, we've got People's Evidence 35 and 36 up here in the screen, and this is showing what they put up that covered his reimbursement, okay? And he was reimbursed $410,000?
Yeah, I think it got to 420 or 430 somehow, but...
Okay, so it got to 420. We've got a bonus, then 180, 180. This looks like 420 down there. You're right, use 420 divided by 12, $35,000 a month. That's the right number, correct?
That is how much they agreed to pay Cohen after the election in 2017.
Okay.
Let me just stop and make this important point. This is an election fraud case. That's how the prosecutors described it.
Right.
This is election fraud, pure and simple, they said in the opening statement. But all of this, everything Trump did, happened after the election.
Trump's people.
Trump's people.
This all happened after the election because it says January 2017, start $35,000 a month, January 2017. The election was in 2016.
You can't have election fraud after the election.
So this happened after the election. These business records that they got him on for election fraud happened after the election.
Yes.
How can that be election fraud?
Nothing that happens after the election could be election fraud, including that.
Okay. Also, there's been a big flap about the judge said it didn't have to be unanimous. That's how you interpret it. It did have to be 12-0, but what he was saying is it didn't have to be unanimous about what the second crime was. They did have to be 12-0. They just didn't have to be 12-0 on what the second crime was. It could be 4 for this, 4 for something else, 4 for something else. Now, I've never heard of that, but apparently in New York, that is allowable. Is that right?
I think there's a big debate about that. I think that's going to be a point on appeal because New York, like every other state and like every federal court, requires jury unanimity in a criminal case. You can't have a 10-2 verdict like we have in Texas state court cases. You got to have all 12. And if you don't, you have a hung jury. So the issue was whether if all 12 of you think this guy did something wrong, but you don't agree about what it was that he did wrong, can you convict him? And the judge said, yes, you can. And I don't know how that will ultimately be answered, but my instinct is that's wrong, that they all had to agree on at least one of the 3 allegedly criminal second acts in order to convict him. It would be, here's a simple way to look at it. Let's suppose somebody is arrested and tried for murder and bank robbery, and the jury says, we don't know which one of these he did, but he did one of them, guilty. I don't think that verdict would result in a sentencing. I think that would be a mistrial.
So you think them not specifying the second crime could be a point of appeal?
I do. And the judge, to avoid the possibility of this confusion, did not ask the jury special questions, special interrogatories. Do 12 of you think that Trump intended to violate the federal election code? Do 12 of you think he intended to violate New York election law do 12 of you think he intended to violate the federal tax laws? He did not ask that, so we're left without knowing whether 12 of them agreed that he did any of those crimes.
Okay, so what was the second crime that they convicted him on?
Well, they got a choice of three things. One was that he violated New York election law by unlawfully paying Stormy to promote Trump's election.
Okay, so violating New York election law.
Yes.
Okay.
The second one was violating federal election law by not reporting the payment to Stormy or to Cohen, and it wasn't clear which they were saying, as a campaign expense. The government said that this, when you paid Stormy or reimbursed Cohen, that was a campaign expense. And under federal law, you have to report campaign expenses. There was and still is a big argument about whether, as a matter of law, paying a porn star to not say, I had sex with that guy, was a personal expense, unreportable, or a campaign expense, just like paying for TV ads or paying your staff. And the state's argument was, yeah, that's just like paying staff, paying a porn star.
Mm-hmm.
That argument should not have won, but it did. And the third choice that the judge gave the jury in the charge was that Trump violated the federal tax laws. And this one is the strangest of all. The federal tax law violation was said to be giving Cohen a 1099. That's a tax form that says to the recipient, you've received this much income, and the government gets a copy of it, and the government knows that he has to pay tax on that. So the violation was said to be $130,000 of the amount that Trump paid to Cohen was just to reimburse him for the amount he had paid to Stormy, which was $130,000. But Trump's organization gave Cohen a 1099 for that $130,000. And Cohen paid taxes on it. So Cohen ended up paying more taxes than he owed because he didn't owe taxes on that $130,000. But once he got a 1099, he had to pay taxes on it. So the crime was you gave Cohen a false 1099, treating his income something that wasn't income. It resulted in Cohen's overpaying his taxes. The government is better off for it, but you are a criminal because that 1099 was fake.
So if they get him on that one, it's for causing someone to pay too much tax.
Yes, but their argument is for lying about how much income that guy had.
Got it. So if we back up and say paying hush money is not a crime, then how does this case ever get out of the starting blocks? How does it ever go day one?
It is stillborn.
There's no case.
There's no case.
All right. Let me ask you this. Harvey Weinstein walked out of a New York prison recently because they said references were made in that case about 3 women that were not part of that case. There were 6 women. 1, 2, and 3 were part of the case. 4, 5, and 6 were not part of the case. But 4, 5, and 6, evidence about 4, 5, and 6 were allowed into the case. And they said that was prejudicial, should not have been allowed in. And so they had to declare a mistrial and vacate that verdict, correct?
They granted a new trial. To be clear, he was on trial for having accused of raping 3 women. The judge let the prosecution introduce the testimony of 3 other women that they got raped too. And they told Weinstein, the judge did, that if you take the stand, I'm going to let the prosecutor, cross-examine you about every complaint that anyone has ever made about sexual abuse by you. So Weinstein didn't take the stand. The Court of Appeals said, There was no basis for either admitting the testimony of those three women who were not in the trial accusing him of rape, or for threatening him that if he takes the stand to defend himself, they're going to let the prosecutors gut him with a bunch of other irrelevant stuff. So there's a rule of evidence that says when the probative value is substantially outweighed by the unfair prejudicial effect of evidence, it cannot come in. And so that Court of Appeals reversed the case and sent it back for a new trial. Here's a point to bear in mind about this. When you've got a judge running with you, as those lawyers did in Harvey Weinstein's case and as these prosecutors did in Trump's case, you got to be careful what you ask for because you're probably going to get it. And if you ask for more than you're entitled to, you've just created a reversible error and the case will be reversed. What happened here, though, is that these prosecutors don't care. They wanted, in my view, this is just my opinion, they wanted a judgment. They wanted a conviction. They don't care if they get reversed. They got an election coming up. If they can get a conviction before the election, they win. If he gets reversed thereafter, so what?
They don't care. So this judge, Mershon, warned Trump that if he testifies, he can be cross-examined about E. Jean Carroll, defamation and sexual assault verdicts, about breaching Mershon's gag order, and about getting hit for $450 million in the Attorney General's civil case. So he says, you can take the stand if you want, but I'm allowing them to cross-examine you about E. Jean Carroll's defamation and sexual assault verdicts.
About a whole bunch of stuff that has nothing to do with this case, but is really stinky.
That's not probative of anything concerning this case. It's not probative of violating Business Records Act.
Yes.
So allegedly assaulting someone in a dressing room in a department store, what does that have to do with business records?
Yeah.
Nothing.
That's right.
So it's not probative of anything concerning this case for the jury to hear, but it certainly is prejudicial in saying you're not a nice guy, you're not a good person, and that you've had these findings against you. So he says, if you take the stand, they're going to let them cross-examine you about all of this stuff. And when that happened in the Harvey Weinstein case, it got thrown out and set for a new trial.
Yes. I actually thought when he let that evidence in Trump's case that, and we then soon thereafter had Harvey Weinstein's reversal, which came from the highest court in New York, the top court. I thought we would see a motion for mistrial in Trump's case right then. I'm surprised that we didn't, but it will be a point on appeal.
Why do you suppose they didn't move for mistrial at that point?
They have confused me with a lot of their strategy and tactics. I don't know.
They got that instruction from the judge. If you testify, you can be cross-examined about this. They let in the testimony of David Pecker, who was an alleged co-conspirator, saying that he had made a deal, a non-prosecution deal, on the catch and kill. They let in that Cohen had pled guilty, alleged co-conspirator with Trump, and said, we're not going to let this in any way to imply that Trump is guilty. It's only for context. But then in closing argument, Steinglass said Cohen got orders from Trump directly about the very thing that they are alleging he did, which was not in evidence. How can they let that in front of the jury and that not be prejudicial to the defendant?
I think this is the worst evidentiary ruling that the judge made and the most obvious ground for reversal. It is a little bit different from your description of it. The indictment did not charge a conspiracy. There were no co-conspirators. So there's even less reason to suggest that evidence about the wrongdoing of Pecker or Cohen, their guilty pleas and non-prosecution agreement, there's less reason to let that in than if they were co-conspirators. But the law is settled in criminal cases that the plea of guilty by one person is inadmissible against the defendant at trial. And the reason for that is that it is so unfairly prejudicial. Well, if he pled guilty to it, this guy did the same thing, he must be guilty too.
Well, how do you describe them if not co-conspirators? How would we
They
describe
described them
Pecker
as
and
accomplices.
Accomplices, okay. Accomplices.
And so Trump, I'm sure, did object to the admission of Cohen's guilty plea, but it wasn't just that they let it in. They questioned him about it, and Pecker too. Did you plead guilty? Yes. Of election fraud? Yes. For what? For paying Stormy? Yes. I pled guilty to that. That was a crime. I was guilty of it. There was a significant exchange between the prosecutor and Cohen, who played up the significance of this guilty plea. And the prosecutor persuaded the judge to let this in with an argument that makes no sense at all. It is settled that if you're convicted of a crime and a guilty plea is a conviction, it is admissible against you by someone who is attacking your credibility. If you commit a crime and I want to tear you up, I want to keep the jury from believing you, I can put that crime in evidence. But this time the state was saying, Cohen is a believable guy. We want the jury to believe him, but we want to attack his credibility with this plea of guilty to election fraud. And the judge said, okay. But only Trump had the right to make that argument that you can't put this in. You can put this in to attack Cohen's credibility. And Trump didn't. Trump was on the opposite side, and yet here it came. And in closing argument, as you said, the prosecutors went back to it and said, look, we're saying Trump intended to commit a violation of the federal election laws, and Cohen pled guilty to it. That was wrong, and it could clearly have driven the verdict. That will get the case reversed all by itself.
Steinglass said, and I quote, "It's an established fact that Michael Cohen committed federal election law violations on direct orders from Donald Trump."
Yeah.
Now, the judge had said that Michael Cohen's pleas only used for context not to imply Donald Trump guilt. And he overruled the objection then, and he overruled the objection earlier.
It's puzzling. That's the nicest way I can put it.
That's the nice way I've ever heard you put something like that. Steinglass said Hicks cried because she knew she had destroyed Donald Trump's defense. I can find nowhere in the evidence that Hicks said, "I'm crying because I know I destroyed Donald Trump's defense." Is it not true that you cannot argue facts not in evidence on closing argument?
You can't. Now, I will say this about that. You can draw inferences. You can say you saw her cry. Here is the best reason that you can come up with for her crying. I'm not as offended by that one because I think the prosecutor was free to say, this is why she cried, and Trump's lawyers were free to say, no, she was crying because she didn't think Trump had done anything wrong, and the prosecutors were trying to use her to put Trump in jail.
But they can't say that because in New York, the prosecutors go last.
That was the worst part of the procedure, and apparently there's no complaining about that. But the prosecutor said everything you've read after the defense had closed, and there was no way for the defense to come back and say, "Well, that's bullshit."
They can't because they're done.
It's too late.
They've said what they've said, so they can't get up and say anything. That just hangs out there. I mean, they can stand up and object during closing, right? That's not good form, but I guess you can.
You can. And, we don't know exactly what those lawyers did to try to stop some of what was happening, what they said, actually, at least I don't. But you can start making speaking objections, and that's where instead of saying, that's not an evidence, Your Honor, you say, Your Honor, he knows good and well that That is not in evidence. That's just his wild guess, and he's wrong about it. What she really was crying about was, they could have done that, and the judge would have slapped them down, and the jury would have seen the judge slap them down, and it probably would have been ineffective. So they were between a rock and a hard place, Trump's lawyers.
If you would, talk about Hornbook law or black letter law. What does that mean?
It is law that is settled and that no lawyer, no judge should dispute. It's been settled for a long time.
Case law,
interpretations of statutes.
Examples would be that guilt must be proven beyond a reasonable doubt. Negligence is failure to use ordinary care.
Yes.
It's just things that
Yes.
everybody knows it.
Yes.
There were Hornbook rules violated here. And one of them we talked about that if A has a plea of guilty, it's inadmissible in a related criminal case against B, and that was violated here.
Correct.
And it was violated here because Cohen's guilty plea came in. He took the stand, confirmed it over and over. And a second one is evidence whose unfair prejudice outweighs the probative value is inadmissible. That was violated as well. Is that something that will be reversible error in your opinion?
Yes. After the election.
Yeah, after the election. Threatening someone with what they can be cross-examined on is a third example. If these things are all black letter law, if these are Hornbook, was the judge in on this? Or was this something where the prosecutor just got on a roll and was getting away with things and be careful what you ask for? Or is it just he doesn't care if he gets, like you say, I don't care if I can hold this on appeal or not. Doesn't matter.
The judge did seem hostile toward Trump's lawyers, and he did allow a case that should have been stillborn to proceed. So I guess the way we should think about this is damning to respect for our judicial system and for the rule of law. When you have a case so infected with prejudice and bias and judicial errors and political prosecutions to serve a political purpose, the whole country is concerned about it. There are even, as I'm sure you've seen, many learned commentators on the left who have arched their eyebrows over a lot of what happened in this trial. It just wasn't right.
Was the goal here to just be able to say convicted felon?
I believe that was clearly the prosecutor's goal, and I think the judge was comfortable with that result.
The ABA standards 3-1.2, functions and duties of the prosecutor, read as follows. A, the prosecutor is an administrator of justice, a zealous advocate, and an officer of the court. The prosecutor's office should exercise sound discretion and independent judgment in the performance of the prosecution function. B, the primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict.
That's a very high standard. And let me give you an example of how it was recently met. Scotty Scheffler got arrested by a cop who accused him of ignoring his commands and dragging him along by the side of his car. Scheffler said, I thought I was doing what this other cop wanted. I didn't realize you were holding on. It was just a mistake and a miscommunication. The prosecutor in that case looked at all of the evidence, talked to the cop, looked at the cameras that had recorded this and said, I can't prove a case here. I'm going to dismiss it. But he had been charged by the cop with a felony for assaulting a police officer. That's what a good prosecutor would do when someone brings a case to him. He would look at it, can I prove it? And then say, no, if I can't, well, I'm not going to bring this case. That didn't happen here. These prosecutors did not meet the bar that you just read.
When he was on the campaign trail and he said, I'm going to get Trump, At that point, should he have recused himself?
Well, you mean, of course, he wasn't the DA yet, but when the case came before him, he should have either declined to prosecute it or himself, just saying there's no case here, or recused and said somebody else in New York needs to bring this, not me, because he had demonstrated bias. It is the same bias, by the way, that the federal judge in charge of the federal case against Trump, accusing him of wrongdoing in connection with the January 6 riots, that judge, before she got that case, said on the record, in effect, in substance, Mr. Trump belongs in jail. She said that in response to one of the defendants she was sentencing, a rioter, someone that broke into the Capitol. He was saying, well, I was just doing what Trump wanted. And her answer was, well, he's not here. He should be. So she has admitted bias against Trump. And they asked her to recuse. Trump's lawyers asked her to recuse. She said, no, I'm not going to. This judge was also asked to recuse, but for different reasons. And they, to me, are less compelling. That different reason is that his daughter was a Democrat fundraiser.
We asked you how the prosecutors described their case. You said directly from them, they said it was a conspiracy to help Donald Trump get elected through illegal expenditures, to silence people who had something to say about his behavior, using doctored corporate records and bank forms to conceal those payments along the way. It was election fraud, pure and simple. But conspiracy was not in the indictment.
It wasn't.
You just corrected me. I said co-conspirators. You said, no, they were accomplices, not co-conspirators. That wasn't in the indictment.
It wasn't. And a number of people who are, I think, have a deep knowledge of criminal procedure have said, and I agree, if it's not in the indictment, you can't prosecute somebody for it. What the state did here was put a whole bunch of stuff in a separate document called a statement of facts. He was not charged with any of these things, but the state prosecutors, when they released the indictment, also released this separate document that said, well, here's some of the stuff he did. We're not going to charge him with it, but this is what he did. So that was the excuse for allowing into evidence this conspiracy theory, because conspiracy was in this second document. Trump conspired with Cohen, and he conspired with his own people to hide the payment process, the exhibit you had on the
Exhibit 36.
Yeah, Exhibit 36. That was all said to be a conspiracy, and that was described in this separate document. But due process, in my understanding, requires that the defendant be told in the indictment what it is he is accused of doing.
It also said illegal expenditures, and you're saying there weren't any.
Exactly.
There just weren't any illegal expenditures.
There were not. And
that they were using doctored documents, but they weren't Trump's.
That's right. It was Cohen's. Cohen created a separate entity to borrow the money and make the payment, and several other related documents that he used to make the non-disclosure agreement with Stormy. Trump was said to be responsible for those kind of phony documents. I mean, there was no reason to create another company to make the payment or borrow the money. Trump was said to be responsible because he conspired with Cohen to get that done. But the indictment doesn't charge him with conspiracy.
It doesn't sound like a law school professor would score this very high in terms of how they brought this case.
You know who Alan Dershowitz is.
Yes.
He's a famous and still brilliant at the age of 85 constitutional law scholar. Taught law school at Harvard for many years and has been hired in multiple high profile criminal cases. He's still talking about cases, including this one, and he is up in arms about how this judge has handled this case. He minces no words. And he describes himself as, I am a liberal Democrat. I have voted against Trump twice, and I expect to vote against him a third time. But this is wrong.
This is one of my concerns, because when I look at this, This is not about Trump. I think depriving someone of their liberty in the United States of America comes at a very high standard and well should. And I don't know what liberties they're going to deprive Trump of. I mean, they could deprive him of his liberty to vote, to own firearms. They could put him in jail. They could deprive him of his liberty to travel freely. I don't know what liberties could be impacted by this, but to deprive someone of their liberty in America comes at a very high standard. It's not a preponderance of the evidence, which is the lowest standard that a jury looks at. A preponderance of the evidence is when it can be 51-49. It's more likely than not, we find for this side. Clear and convincing evidence it's just what it says, clear and convincing. It looks pretty likely that's what happened. But beyond a reasonable doubt, I've worked with juries most of my professional career, and I've always interpreted that to mean that you send 6 or 12 people into a room and they debate, talk about this, and they conclude that there's no issue here about which reasonable people could disagree. These things are clear. There's just nothing here about which reasonable folks could disagree. And that's a pretty high standard. It seems to me that there are some things that lead up to that you're entitled to face your accusers, you're entitled to know what you're charged with, and then you have this standard where people have to reach beyond a reasonable doubt in their findings, and it has to be unanimous. They've just run all over these standards in this case. And if they can do that to a former president of the United States, and that's allowed to stand, what happens to the average citizen? What happens to somebody that gets hauled into tax court, for example? If these standards all of a sudden just get thrown to the side and they don't get due process. Isn't this jeopardizing all of us?
You started by saying this is not about Trump. I would amend that slightly. It is about Trump because the case wouldn't have been brought if Trump were not the guy.
Good point. It's not just about Trump.
It is about much more than Trump.
Right.
And what has happened to Trump, if it can happen to him, it can happen to anybody. And when Trump has said, as he frequently says on the campaign trail, if they're coming after me and you're next, I'm stopping them. I'm standing in the way, and I'm going to stand up to them. He needs to do that, and he needs to say that. But you're right. What has happened to Trump is all of the things you said, plus the evidence that was admitted and excluded in this case was erroneous. If it can happen to someone like Trump, it can happen to the least of us.
There are a lot of people listening to us right now and watching us right now. What should the message be? What should people take away from seeing what's happened here? You've been very clear that this case should never have been brought. I agree completely. And it doesn't matter whether you're a Democrat, Republican, pro-Trump, anti-Trump. It doesn't matter. What we're talking about here is this new term that's been coined, lawfare, that warfare has moved into the courtrooms. Lawsuits are being used as a weapon. So it doesn't matter if you like Trump, don't like Trump, Democrat, Republican. This is terrible. It smacks of banana republic tactics. What's the takeaway here? What should people take away from this?
I agree that the stench arising from this case is something you can't miss, and we have an imperfect but wonderful judicial system in this country. Our jury trial system works well. It doesn't always reach the right result, and it requires people who are involved in that system to be respectful of it. And when you have, as we saw in this case, a prosecutor and a judge who don't treat the case as the law requires, who are concerned most about winning and not about doing what's right and what the law requires, you send a message to the rest of us that we just can't trust lawyers or judges or the results of trials. And there's been a lot of talk about the loss of respect for the law, and much of the time people are saying Trump is the assailant, the one who is threatening the rule of law. It's the other way around. Trump is the victim of this assault on the rule of law, and that's what it was.
This should be reversed. We know they don't care about that, but this should be reversed.
It will be.
It'll be thrown out.
Yes.
And when it's thrown out, the options will be to just vacate it or to retry it?
It depends on the basis on which it is reversed. If it is reversed on the ground that, A, the payment of hush money was not a crime, B, the cover-up was not a crime because you can't, if what you're covering up wasn't a crime, covering it up isn't a crime. C, there wasn't any election law violation, either state or federal. If it's thrown out on those grounds, it's over. It can't be retried. If it, however, it is reversed on evidence grounds, that you shouldn't have admitted this evidence, you should have admitted this other evidence, then there could be a second trial.
You think they'll be motivated to do that?
Well, I think it's going to get reversed and rendered on the law points that we mentioned.
So it won't be remanded, it'll be rendered.
I think so.
Yeah. So what will happen now? July 11th, Trump goes back for sentencing.
What's that, like 2 days before he gets the nomination or something?
4 days before the GOP convention.
Nobody knows what this judge will do, and he's full of venom. But I cannot imagine that his sentence will be to put Trump in jail. And if he does sentence Trump to jail, I believe he will suspend the sentence pending appeal. And if he doesn't, I believe Trump will be able, in short order, to get the Court of Appeals in New York to suspend the sentence so that Trump will get the nomination and run. The practical issue is this felony conviction going to hurt him or help him? My own guess is I don't see how it helps. It certainly galvanizes the people that are going to vote for Trump anyway, makes them more determined to do so. But if I'm sitting on the fence and somebody says to me, well, aren't you going to vote for Trump now that he's a felon? I don't see many people jumping off the fence in Trump's direction.
If he puts him on probation, will they stay that?
You know, it depends on the terms of probation. Most of the time, maybe all the time, someone on probation has to report into the probation officer and can't leave the state or the city or some confinement like that without permission. I can't imagine that being done to somebody who's in the midst of a 50-state political campaign. So I think that too would be suspended.
Surely it will.
Please.
Surely it will. Is there anything I haven't asked you about this so far? There's some details we're going to go into on the show, but is there anything I haven't asked you about that you feel a need to say in this conversation?
The only other evidence point that we ought to talk about is the exclusion of the expert witness that Trump offered. Once the state was allowed to put in Cohen's guilty plea to a federal election law violation, Trump should have been entitled to bring on a witness who would say, what happened here is not an election law violation, and then talk about the difference between the campaign expenses, which you have to report, and personal expenses, which you do not have to report. And he should say, a campaign expense that has to be reported is something like paying for television ads or paying for office staff or rent. That has to be reported if you spend that money. But if you spend it to silence a hooker, that's a personal expense. And you don't have to report them. And here's some other personal expenses that Trump has every day. He dyes his hair. He gets under a sun lamp. He uses a lot of hairspray. Those are personal expenses, and they don't have to be reported, and neither does paying a hooker.
Well, they had Smith, former chairman of the Federal Election Commission, who was prepared to offer testimony that the things they were complaining about would not have been violations for a variety of reasons. One, that the business records occurred after the election and therefore could not be part of a conspiracy or violation of election law. That was part of his testimony, correct?
I doubt it. He was an expert on what's a campaign contribution and what's a personal expense. And that's a different legal question. It doesn't really have to do with the ins and outs of campaign finance law. The only thing it has to do with is that you don't have to report them until after the election. So had he reported them in a timely way, it would have been after the election. He could have said that.
He could have said that. But he did an investigation. Who did the investigation in 2016?
He was on the Federal Election Commission that declined to pursue Trump for violating the election laws, for doing exactly what Alvin Bragg, the district attorney, said Trump had done.
He declined to do the investigation?
He did the investigation. He declined to prosecute.
Okay. He found no violation?
I don't know if it was a formal finding. I think it was. I think they wrote an explanation for why they weren't going to pursue it.
But they did find no violation, no fine, civil or criminal, and he was going to testify to that.
Yes.
Which would have offset
the Cohen's testimony about, I'm guilty, I violated the election laws by paying Stormy and not reporting it.
Why was that excluded? What was the reason given?
It is pretty well settled that you almost never, there are some cases that I have had experience with where an expert is allowed to testify about the law, but it's when the law is really arcane and not many people know it or understand it. Generally speaking, the jury gets its law from the judge. And generally speaking, you don't call an expert to come in and say, well, I know there's an election law violation alleged here, but there wasn't one, because he's usurping the duties of the judge. And that would have been a good reason to keep it out if the judge hadn't let Cohen's plea agreement in and let them question Cohen about pleading guilty and being guilty. But once that door was open, in my view, the judge should have let it in, let the expert testimony in.
Why wouldn't they have moved for a bill, sent the jury out, and put it in the record?
We don't know that they didn't, but they certainly should have sent the jury out, put that guy, Brad Smith, if that's his name, on the stand and asked him the questions that they wanted the jury to hear. And then having completed that, they should say to the judge, I want you to let me do this in front of the jury. Will you do it now that you've heard it? The judge would have said no, but by making that record, by asking those questions and getting those answers, they would have preserved this point for appeal. It may not have been preserved.
So if they didn't do that, they may have waived that?
Maybe. It depends on the colloquy that went on around it.
Depends on what they said back and forth?
Yes.
That would be too bad.
He's got enough. He's going to get this thing reversed.
Either way?
Yeah.
Even without
it.
We'll talk about that some more. Anything else?
I can't think of it.
I wanted to share my final thought about this. This weaponization of our great institutions, the FBI, Justice Department, and individual states' similar institutions, will lead to one of two outcomes. One is more of the same from the other side, tit for tat. That may seem deserved, but it is not the right way forward for America. The other is what I call on you to demand from your politicians today, an end to this craziness in order to save the soul and sanity of our country. The Pope has actually given us the right approach in his new book when he says, we are all brothers and sisters, and there must be no resentment among us. For any war to truly end, forgiveness is necessary. That is true of any war, including our current cultural war. We need our Justice Department to return to the business of meting out justice and not running the political agendas of those currently in power, blindly seeking convictions, warranted or otherwise, and attacking political opponents. That requires a very few important things from each of you, from all of us. Finding your voice, forgiveness, and focus on the way forward. Forgive them, for they know not what they do. Forgiveness, and at the same time requiring better. We are not some banana republic, for God's sakes. What are we going to do next? Have a Putin poisoning posse and start finding political opponents foaming at the mouth at home, not so mysteriously dying in their lazy boy recliners? We're better than that. We must be better than that. I don't like what I see happening in our country. This kind of thing is exactly why I launched Merit Street Media and wrote, We've Got Issues. I don't like seeing the weaponization of our justice system, agencies, and powerful government actions that, frankly, just make my skin crawl for all of us and for my grandchildren. And let's be honest, this is so not just about Trump. If you let your hatred for Donald Trump compromise your ability to find true north on your moral compass, shame on you. If you let your disgust for Biden make you blind to the inevitable consequences of pursuing revenge, then God help the children who will inherit the dystopian nightmare we create. We need leaders who will pledge to end this vicious cycle right now and return us to that safe place where our institutions are no longer bastardized and weaponized, but rather simply serve their intended purpose. We have serious problems to solve, and it will take serious people to solve them. Men and women who we hold accountable for doing that which they were selected or hired to do. They need to know we are watching, and their positions are privileges, not legacies. They work for us until they don't. I'm not into politics. I claim no expertise, nor do I seek any. I don't advocate voting for one candidate over another. I stay in my lane addressing human behavior collectively, culturally, and am focused on how we can have maximum control in our lives and turn this ship of state called America in the right direction and get her back on track so we can be proud. That's my mission, and this is a call to action to save our collective soul and sanity. This is also a call to redemption, healing, and forgiveness that leads to peace among us all, which is the most important gift we can share in our dangerous world. The current administration could and should do the right thing. Dismiss now, even now, post-conviction of a political opponent, all such lawfare, and pledge to return to the normal functioning of a government rightly run. God bless you all, and God bless these United States of America.